All right, we're going on Zoom on cause number DC 201465, Choppa v. Dave & Buster's, Inc. Parties have elected not to have a court reporter's record for this. Let's go ahead and get started, and just if you guys could announce your names.
T. Wen, Your Honor, for plaintiff.
Ken Riney on behalf of defendant Dave & Buster's. Also have our associate Clayton Carter, who did the briefing and will be arguing for defendant.
That's great. Okay. You can proceed.
Your Honor, this is a situation where the defendant sent out a DWQ for 37 questions to two medical providers that treated plaintiff, and my client does not have Medicare. And this was a situation at Dave & Buster's where there was a shooting between customers, and my client happened to have been in the wrong place at the wrong time, and he got shot by a bullet in his leg. In this case, they sent out these 37 questions, and they wanted to ask some very speculative and get answers that we say are related to collateral source rules, in that he does not have insurance, private medical insurance. He does not have Medicare or Medicaid. And I'm okay for defendants asking for all of the related questions to proving up the records, proving up, paid and incurred, getting the different answers to, what has been adjusted. But what I'm objecting to are these very speculative, very broad questions to them. For example, do you agree to accept Medicaid or Medicare for payment of services and supplies furnished to Dr. Choppa? And that's my client, Your Honor. And then, they go on and they ask, do you understand that in compliance with state and federal regulations, the healthcare providers charge in excess of Medicare or Medicaid rate should be written off, discharged, or adjusted? Now, they go on and they're very broad in their questions. And I think the first, 19 questions are valid. And I even am okay with number 19 when it says, of the total amount charged, please list the total amounts that you expect Medicaid or Medicare to pay. That's a little bit speculative, but since he doesn't have Medicare or Medicaid, there shouldn't be anything expected there. But the other questions, they're just out of line, and they're speculative, and they go and fall under the collateral source rule. And I know that defendants provided some case law, specifically the Haygood case, and all of those references are cited for medical insurance adjustments. There is no medical insurance here, and so there aren't any adjustments here. There is a letter.
Can I ask a quick question? There's this new case out of the Texas Supreme Court. It's not In re Allstate, it's the other one. What's it called?
In re K&L Auto Crushers, Your Honor.
Auto Crushers, that's right. How does that line up with, generally before Auto Crushers, I would have 100% agreed with you and probably sustained all of the objections here. How does Auto Crushers play into these questions?
Well, in re K&L Auto Crushers, they talk about reasonable and necessary charges. And, I don't think it really plays into this. This is all, if you'll look, Your Honor, we look at each question here from 20 to 37. And it doesn't play specifically into reasonable and necessary. It goes into speculating what a particular provider may or may not reduce, for the benefit of the patient. So here I think in re K&L, it talks about the issue being reasonable and regular rates. And you'll see that on, I believe, page 5. I don't know if that
Is this the right opinion that I'm looking at, or is this the concurrence? I can't tell.
I have the actual case.
Do you have it? Could you share screen it, or
Sure, I sure can. Hold on, give me 1
let
second.
me stop sharing?
Okay, yep, let me pull it up. Oh, can you allow me to share screen?
Oh, I'm sorry. Let me do that. Go ahead.
Okay. Oops, are you seeing anything yet?
I can see your screen, but I can't see what's
There,
case.
let me get the case back on. You see the case now?
Yes.
Okay, let me make it bigger. And here is part of the opinion. We held 3 terms ago that the negotiated rates a medical provider charged to a patient's private insurers and public entity payers, so they're talking here about private medical insurance and Medicare, were relevant and discoverable on the issues of reasonableness of the full rates of the provider charged to an uninsured patient for the same services. So if they can, ask what are the rates that they charge, insurance or Medicaid, I guess, that would be fair. Here, then they say, we hold that the information we found relevant to the reasonableness of the provider's rates in North Cypress is equally relevant here. And then it goes on and talks specifically explaining to conclude that those negotiated rates have nothing to do with the reasonableness of charges to the small number of patients who pay directly. It doesn't go to the questions that these defendants are asking. They don't ask about negotiated rates. And if we'll go back, let's see here. Oh, I actually have it. I can do it on the screen too here. You'll see here, Your Honor, question 20. Well, let me just kind of go back here. Number 18. Of the total amount charged, list the total charges paid by Medicaid or Medicare. You'll find, they will find, and they know that Dr. Chapa, my client, does not have Medicare or Medicaid. I didn't object to 18. 19, it goes on and asks, what they anticipate Medicare or Medicaid to pay. I didn't object to that. But then they go on and ask these I think very offensive questions to get the provider to answer these questions, like, are you aware that you need to be in compliance to the rules? Are you aware that you need to follow the law? I mean, I don't see how that has anything to do with proving up paid and incurred by my client. And then it goes, is it true that once you agree to accept Medicaid or Medicare, you're required by law to accept the Medicaid or Medicare fee schedule? And then, this has nothing to do with my client. It's not relevant, and it doesn't prove up anything. Here, do you understand that in compliance with state and federal regulations, the healthcare providers charge in excess of Medicare and Medicaid rate should be written off, discharged, or adjusted?
Okay, so let me do this. Let me just go through one by one. So 21 is the first one you was objected to?
20.
20.
Yep.
All right, so 20. I'm going to sustain the objection. 21. I'm going to overrule the objection. 22. I'm going to sustain the objection. 23. I'm going to sustain the objection. 24. Sustain the objection. 25. I'm to sustain the objection. Can we go to the next one?
Okay.
I'm going to sustain the objection. Now, 27, does Auto Crushers discuss letters of protection at all?
Your Honor, I think, give me 1 second here. It references it. Let me take you to.
I believe it
part.
does, Your Honor.
Let me take you to the part, it's page 6. It says here, the reasoning fails here because Walker's providers treated him pursuant to letters of protection in which Walker's attorney promised to attempt to pay the providers only for any reasonable and necessary medical charges. We find nothing in the record that legally obligates Walker to pay the full amount the providers charge if the amount is unreasonable. So.
And Your Honor, I think we can offer a little bit more insight into what that case says about letters of protection whenever the court's ready to hear.
I want to hear that now.
Okay.
Your Honor, the Henry K&L Auto Crushers specifically says that when there's a letter of protection in place, these medical providers who have these letters of protection, since they have a financial stake in the outcome of a litigation, that they are interested parties, that they forfeit a level of protection that medical providers would otherwise have that do not have letters of protection.
Can you pull up the case just so I can see where you're talking about? Where is that in the case?
Yes, Your Honor, I can share that. Is it up there, Your Honor?
Yeah.
Okay, so I have it highlighted here in purple. Here, any way that the provider's non-party status may have had on the burden issue substantially offset by the fact that letters of protection give the providers a direct financial stake in the resolution of Walker's claims. Unlike most non-parties, the providers who treated Walker pursuant to letters of protection invested themselves in the outcome of the case and the amount of damages recovered, and because of that,
let me just ask this: what did they order to be produced regarding letters of protection in this case, just so I can kind of see that?
Your Honor, they have the specific underlying discovery request, Your Honor, but it was just basically everything that had to do with.
Well, can I see can you go to that part, yeah, so I can see?
I was just going up to the holding. So here are the court's holdings, Your Honor.
Okay. Yeah, but what exactly was ordered to be produced, or what did the trial court sustain the objections to that the Supreme Court said was abuse of discretion?
Clayton, it's the next paragraph in the asterisk page 8 that you showed. Okay. If you'll just go down.
Page 8.
Yep. It's the paragraph, although. Yep.
Your Honor, another thing in this case, in Henry K&L, the medical providers themselves objected to the DWQs, and here, these were submitted on May 18th. There have been no objections asserted by any of the medical providers, just from plaintiffs.
Okay, so it talks about North Cyprus. It says, thus the broadly written subpoenas originally sent to the providers reflect that K&L Autos agreed to narrow its request to the information North Cyprus permitted. So can you go to the footnote 13?
Is that too small, Your Honor?
It's very hard to read. I'm sorry. So bottom line, if it complies, I guess, with North Cyprus and NRA K&L Auto Crushers, then it's going to be allowable. If it's not, I'm not going to allow it. but I can't read that. I'm sorry.
Okay, I can.
Your Honor, here, we're not objecting to production of the documents because they can have them, our letter of protection. We're objecting to the questions.
Okay. Okay, well,
Sorry, jumping around.
I'm just trying to figure out what that says.
Sorry, Your Honor.
All right, is this, oh, okay.
Zoomed it in, go back to footnote 13.
All right, let's see. Okay, stop. Okay, so this is what's allowed. All contracts regarding the rates private insurers pay for the hospital services provided to the plaintiffs, the Medicare and Medicaid reimbursement rates for the services provided to the plaintiff, and North Cyprus's annual cost report it provided to Medicare for a 5-year period. So that's the scope of discovery, I would think. Am I missing something? It's addressed to the parties.
Oh, no, Your Honor, I think that's fine. I think these questions here, do you accept letters of guarantees?
Can you go back to the requests again?
Sure. I'll unshare.
Oh, can someone share the requests again? I apologize.
Yes, I will. You see that, Your Honor?
Okay. So 27, that the objection 27 is overruled. 28 is overruled. 29.
Let me move. Oh, you see it.
29 is sustained. 30 is sustained. 31 is sustained. 32 sustained. 33 is sustained. 34 sustained. 35 sustained. 36 sustained. 37 sustained. So I just want to make clear that anything, if I've missed something in, that's directly on point to any of those requests involving in-ray auto crushers or the, what is it, North Cyprus case,
Yes.
can you bring that up now? It's because I'll reconsider if there's something on point in either of those decisions. Mr. Carter?
Your Honor, I think the main point is these, if there are adjustments to the agreed amount willing to be paid pursuant to a letter of protection, then that still bears on the reasonableness of the charged medical expenses.
Does it discuss that? If it weren't for the Supreme Court, I would never allow you to discover this, but if the Supreme Court is going to require me to do it, and there's something on point that says I have to, I will comply with the Supreme Court. But if it's not in there, is there something in there specifically in the opinion that says that I have to order any of these things?
Not that I've seen, Your Honor.
All right. Thank you for your honesty, Mr. Carter. All right. Anything else, guys?
No, Your Honor. Should we submit an agreed order?
Yes. So Ms. Nguyen, write this down carefully, please. So if you can submit an order to me that says on June 21st, 2021, the court made the following order, and then list out what I've ruled on. share that with Mr. Carter or Mr. Riney. Mr. Riney, who do you want her to share that with?
She can share with both of us. That's fine.
With both of you guys. One of them will need to hopefully sign off on it, and then email Rhonda the proposed order and e-file it as well.
Great. And just to clarify, it looks like, Mr. Riney and Mr. Carter, it looks like number 21, 27, and 28 are the only questions that were overruled.
That's what I'm
That's right.
showing.
Thank you.
Okay, anything else, guys?
No, Your Honor.
No, Your Honor.
All right, guys, you guys be safe, okay?
Thank you.
Thank you, Your
Have
Honor.
a great afternoon.
You too. Okay, is everyone here on the Cabrera case? Are both sides here on the Cabrera case?
I see Mr. Markle. I don't know that I see anyone from the plaintiff side. And it would only be plaintiffs, Mr. Markle and I that have any real interest in this stuff.
Miss Cheryl is here. Who are you here with? Miss Cheryl, who are you here with? We can't hear you. Who's Miss Cheryl here with?
Maybe Mr. Rowland's office?
Yes, can you hear me now?
Yes, we can.
Okay, sorry. Yes, I'm here with the Bassett firm in Mr. Rowland's office. He had federal trial today.
All right, so no one's here with the plaintiff's office? Oh, I see MDLC. Who's that?
That's Mr. Markle.
That is Melissa Beach's lawyer, Your Honor, Spencer Markle. That is, I guess, somebody from my office.
Daniela Saib?
Yes, she's an associate with our firm. So,
Okay.
yeah.
Okay. Well, do you want to reach out to Mr. Casada and see if he's going to sign on? Maybe he forgot, or maybe it wasn't clear we were doing this.
Yeah, maybe give me a second and I'll reach out.
Well, while we're waiting, why don't we have the interns introduce themselves? Alex, you want to introduce yourself?
Sure. Hi, my name is Alex Marlowe. I am a Rising 2L at UNT Dallas. I graduated from Texas A&M in 2020, where I was a member of the equestrian team.
Alexa?
Hi, I'm Alexa De La Vega. I'm a 2L at Baylor Law School, and I went to UT for my undergrad.
And Chris?
Hello, my name is Chris. I am 2L at Baylor Law School. It's a pleasure to be here with you.
And we have the SMU triplets. You guys want to each introduce yourselves?
Hi, we're all sharing a screen. My name is Caleb Degler. I am currently a rising 2L at SMU, and I graduated from Texas A&M for undergrad.
Hi, I'm Brennan Wong. I'm also a rising 2L at SMU, and I went to Wake Forest for undergraduate.
Hi, I'm Casey Jones. I'm a 2L at SMU, and I went to Texas Tech for undergrad.
Guillermo?
Hi, my name is Guillermo Gomez. I went to Harvard for undergrad, and right now I'm a 2L at A&M.
Ashley?
Hi, my name's Ashley. I went to William and Mary. I go to William and Mary Law School, and I went to Texas A&M for undergrad.
So Miss Sabi, is that your name? Sabe?
Maybe, Your Honor, yes.
Sabi, where did you go to law school?
For my LLM, I went to University of Houston, here in Houston, but for my undergrad, I went back home. I'm a foreign attorney.
Okay.
Yeah, I'm from Honduras.
Oh, great. I had an attorney, I've had an attorney licensed in Mexico as an intern and an attorney licensed in Brazil, but never Honduras. So that's interesting. Mr. Markle, where did you go to law school?
University of Pittsburgh, Your Honor.
Pittsburgh. Mr. Bennett, what about you?
Harvard of the West, University of Utah.
Miss Cheryl?
I went to the University of Arkansas in Fayetteville.
Fayetteville, all right. So no SMU people or UT or A&M here. So, well, any luck reaching Mr. Casada?
I just tried his office, and the receptionist told me he's on a Zoom. So I don't know if he's stuck or having problems or on a different Zoom altogether. I couldn't get that information out of.
Let's just see.
I also sent an email with the link that Ms. Pinson had already sent. So
I wonder if he went to the wrong link. Sometimes people get confused.
that could be.
Well, while we're waiting, can you remind me kind of what we're covering today?
Sure. There's two issues. The first issue is an in-camera review of employee personnel records. We Bates those and sent them via email to Ms. Pinson. It's about 100 or so pages of those.
That's right. And they weren't Bates stamped before, right?
Correct.
Okay.
And then we just had some questions about the order about Ms. Eagle's prison deposition.
Okay. All right.
Oh, Mr. Casada is online.
There's Mr. Casada. Okay. You're muted.
Sorry about that, Your Honor. I just mixed this up on my calendar. I apologize.
That's okay. Miss Wong, Brennan, can you go ask Rhonda to email me? When did you email the in-camera Bates stamp documents?
Hold on. I can tell you it was last week. Let me see.
Can you grab Rhonda?
Or it might have been this week. Oh, 17th, last Thursday.
And that was Mr. Bennett, you emailed it?
Yes, Your Honor.
Okay. I don't believe I've seen those, so she may have gotten it and just not realized she needed to forward it. Yeah, I don't see that I've gotten it. Let me see.
Judge, are you going to need me?
Oh, you know what? No, I think I'm good. Just if you could lock the door, that'd be great.
You have a great evening.
You too. Okay, I did get it actually. She did email it to me. I'm sorry. Let's see. Did you send this in a zip drive? Is that right?
A zip file, yes, Your Honor. Just to make sure it all made it.
So is this it? What you sent me?
Correct.
Okay, I won't share it. Okay, so let me. Tony, are we on the record?
Not yet, but I'm ready.
All right, let's go on the record on cost number DC 1819366 Cabrera versus Caitlin, Cheyenne, Eagle, council make your appearances. Mr. Casati, you need to unmute.
Your Honor, this is Tex Quesada here on behalf of the plaintiffs.
Joshua J. Bennett on behalf of the Fleet Pride defendants.
Spencer Markle and Daniela Saby on behalf of Melissa Beach.
Kayla Cheryl on behalf of Miss Eagle.
Okay, so there's a request for an in-camera inspection. Let me see. Okay, it's now been, and so what is the issue you're asking me to look for, Mr. Casada?
Your Honor, this has to do with an event that occurs not on company premises, but at a local watering hole. We were looking for anything that has to do with alcohol, anything that has to do with the failure to report or deal with an incident which occurred in July. The crash, which is the basis of the lawsuit, happens in November, but in July there was another event involving
July of what year?
July of the same year of 2017.
2017, okay.
Involving Ms. Eagle and Ms. Beach. And I don't know if there's anything in there about the event. Eventually, Ms. Eagle and counsel, you stop me if you think I'm wrong or if I'm talking out of school here. There were arrangements made for Ms. Eagle to use a company vehicle as a result of the July incident in which her personal vehicle was torn up. And at some point, I think that maybe somebody else in management found out about that, said, no, you can't keep lending her the company vehicle. Those are the sorts of things that I think may be in there. And I can't tell.
Who is Abby Nichols?
Abby Nichols is if I may, oh, sorry, Mr. Casada, I didn't.
No, you're welcome to.
Ms. Nichols is an associate that works at the what we call the Mockingbird location, which is where the inventory project at issue occurred. She's a counter employee, works behind the cash register, pulls parts, things like that.
Was she there when they were out drinking? Was that why she's here?
For a limited period of time. So Mr. Casada can stop me if he wants, but they did an inventory project in the morning till about noon. From after noon, 12:30, somewhere in there on that Saturday. They then went to the watering holes, Mr. Casada termed it. Ms. Nichols was there for about the first 30 minutes to an hour, 1 o'clock, 1:30, maybe 2, and then left. So they've asked for her personnel file, and we've gone through, looked at it, and produced what's there. We filed a notice about this on May 25th about what we looked for and what we found and what we didn't find. So Ms. Nichols doesn't have anything about this event in her personnel file. Neither does Mr. Eckerd, who's very similar to Ms. Nichols. He's not a counter employee. Mr. Eckerd builds axles and some other parts, assembles them at the Mockingbird location, but was present at the inventory on that Saturday, and then went to the bar after the inventory with friends. So they asked for his personnel file. We searched that one. That's also part of the in-camera inspection. Nothing in there about this event in his personnel file. And then the last one's Ms. Beach, of course, who's a defendant.
Can we just do this one at a time? I'm sorry.
Sure.
I'm just looking through the documents. Is Kathy Nichols work for the company or Hillary Birch?
No, they are HR personnel, or were at the time of the documents in question.
Wait.
They
Kathy
are.
Nichols?
Yeah.
Works for the company?
Abby Nichols is still with Fleet Pride.
Does Kathy Nichols, did she ever work for Fleet Pride?
Not that name doesn't ring any bells, Your Honor.
It's Abby Nichols' mom. That's why I was wondering. So no. Okay, it's just listed on one of these forms. Okay.
Probably
All
an
right,
emergency contact form.
So pages 1, 2, 3, I'm going to, I guess, order them not to be produced. 4. What is the date of the accident again? It's
November of 26, November 18, 2017.
all right. So I'm going to order that 4 through 20 not be produced. Okay, so now we're on Abby Nichols still okay. Is there any issue in this case about question? Well, never mind. There's a confidentiality and non-solicitation agreement involving Abby Nichols. Would that somehow be relevant at all, Mr. Casada?
No, Your Honor.
Okay. And this did not happen with any company equipment, right?
Correct.
That's right.
Sorry, this is taking a while. Interns, this is not the most glamorous part of judging. Let's see.
Or lawyering, if I may interject.
Or lawyering, that's true.
I'd take all this off your plate, your collective plates. Just send me the records.
All right, I'm not going to order anything through page 43 to be produced. So Anthony Eccles, he also was not, or Eckerd, I'm sorry, Echard, also was not involved in the accident, right?
Correct. He was at the bar for this about the same window of time that Ms. Nichols was there on the day of the incident. There is an incident that we have a dispute about whether it matters or not, but for purposes of review, it's probably salient. I'm sure Mr. Casada will raise it, which is in July of 2017, Ms. Beach, Mr. Eckerd, and Ms. Eagle went to a bar not related to this bar. And then following that, hours later, so they went sometime in the afternoon of, I think it was July 27th of 2017. And then the following morning around 4 or 5 a.m., Ms. Eagle got in an accident. That's per her deposition. And so I think some of Mr. Eckerd's file, they wanted for that. There's nothing in there about any of those things. But we've given the court what we pulled from Mr. Eckerd's file.
Okay. I'm sorry, what was the date of the other incident? You said that.
I can't give you exactly the date. If you gave me a second, I could. I want to say it's July 27th, 2017, but give me a second and I can tell you specifically.
I'm going to step away and I've got it out in the hallway. I'll be right back.
Okay.
July 26th of 2017.
So
And then,
yeah.
And Melissa Beach,
And
I guess, is there any question that Melissa Beach and any of these three people were company employees? I mean, is there any need to produce anything just to show that they're employees, or?
I don't think there's a dispute about that.
Okay.
There is no dispute about that, Your Honor.
And the drink in the summertime, the drinking was on the 25th of July. The crash is on the 26th.
Okay.
That morning.
I don't really see anything here. Let's see. So there wasn't any personnel action form related to this incident on July 26th or November 18th?
Correct, Your Honor. The company's position, and I'm not trying to go to the merits or anything here, but it's just the company's position that was on personal time. So there was no employment action taken against any of the employees.
Okay. So there's a talk about an employee handbook. That's not an issue here, I guess, right?
We've produced the employee handbook and
Okay.
addenda to it that pertain to, relevant policies, but that's been produced.
Was the company accident prevention program produced?
Yes.
And I guess there's a thing, acknowledgement of safety disciplinary procedures, but this was back in 2012. I don't think that that's going to be relevant. Confidentiality agreement signed by, that's not going to be relevant either. Mr. Casada, is that right?
That's correct, Your Honor. Unless Joshua did have anything to do with this incident?
No.
Okay, then
No,
no.
it's way before then.
Then no, Your Honor.
I don't see anything relevant in here. I'm sorry, Mr. Casada.
Your Honor, thank you for taking your time to go through it, and let's go on to the next issue.
So the second issue, I guess, is the order. What's the issue with the order that I signed?
I don't know if necessarily there's an issue. I think we have some questions, but before we transition there, I just want to make sure. So we started talking about Abby Nichols. So for all 3 employees,
I went through
promotion for
pages
protect-
1 to 103 and I didn't find anything
Okay.
that was
Yeah,
discovered.
that's everything for Ms. Beach included. So thank you, Your Honor. Appreciate that. Thank you.
And so what's the question about the order or the issue or whatever, so we can talk about it?
So when we spoke last week, and I provided a copy of an order to Ms. Bridges, she approved it, and then we gave it to the court. We talked about 1 lawyer for each party being present and in person. I think that's what the order still says, despite the interlineations. But we weren't sure because it provided for 1 attorney.
That was not my understanding. So did you say that you cleared this with the lady? Is that the lady from the prison?
Yes, Your Honor. I gave
my impression
a
was that
word-
we could get 1 more person in. Is she saying that we can get enough? Do they have space that they can let all of you guys go? I thought it was just 1 per side.
So what I understood Ms. Bridges to say, and just to make doubly sure, before we tendered this to the court, I emailed her a Word version and said, is this something that y'all can live with? Exactly as we had it, 1 attorney for plaintiffs, 1 for Fleet Pride, et cetera. And she said, yes, if the court orders it, we'll see it done. So
That was
that's
not
what
my understanding, but if that's let me tell you why I interlineated and then I'm glad to vacate it or modify it.
May I interrupt for a sec? Do we need all this on the record?
What?
Does all this need to be on the record? I don't think
It doesn't have to be if you don't want it to be.
Just to make it easier on your court reporter, Your Honor.
All right, let's go off the record. We'll go off YouTube too, because we're talking